Okay, so good afternoon, everyone. Thank you for joining us today. My name is Pratik Rathi, and it's a pleasure to be here to discuss one of the most significant shifts in the digital landscape we have seen in years. The evolution of data privacy and security in India has something been that a lot of people have been talking about for quite a while, and now we have some new agendas coming in from the government perspective on a day-to-day basis. One of them at a major large scale is India's Digital Personal Data Protection Act. So, a quick brief about the organization before we begin, uh, and give you an overall understanding that who we are, who I am, and what we are here for. So, before we deep dive into the rest of the details, a quick word with respect to CyberQ. We are the lead consulting practice organization. We are a cybersecurity and privacy consulting firm dedicated to helping organizations navigate the complex environments with respect to data protection in both the aspects of information security and privacy. Our goal is simple: to help you build security resilience and stay ahead of the curve. The demand of regulatory environment is ever changing, and it evolves with time. So we try and keep up with the changes that comes into the effect, and we assist our customers with the same. To give you a bit of the background on my perspective, I come from a heavy auditing and compliance background as a certified PCI QSA, QPA, and lead auditors in 27701, 42001, and 27001. I've spent my career helping businesses align their technical operations with global standards. My focus today is not just a checkbox criteria, but on how we can actually use this framework to create a genuine, secure foundation of your data. So that's where we will emphasize much upon. Let's quickly go through the agenda for the day. The agenda in today's session is specifically tailored with respect to India's DPDP, that is your Digital Personal Data Protection Act. We have a lot to cover, and my goal is to make this as practical as possible for you guys. So, uh, before we move further ahead into the agenda, I just want to first let you all know that you can just let me know whenever you have any questions. You can put down it in the chat. I have my chat active with me. I have my team at the back end who will be supporting with me with respect to the questions that you might have. And you can raise your hands. You can pop in the chat box whatever queries you might have, and I'll try to answer to the best of my capability that we can assist you with the same. So first, we'll look at the high-level overview of the DPDP Act and how it matters now, because it's been some time that the act has been in place. There are new rules that have come into effect as well, and we'll go through those. Next, we'll break down through the key roles, rights of the individuals, and your obligations as an entity. And then we'll go into the how, that is discussing consent, notice, and what lawful processing actually looks like in practice and not just on paper. So we'll deep dive into that segment as well. We'll critically discuss the risks, potential penalties, and what the regulators expect from you during a breach. These kind of queries we will be going through. I'll try and explain whatever is there in the act as per these particular pointers. Finally, I'll leave you with a roadmap of practical readiness and next steps, what exactly you should do to make sure that your entity and you yourself are compliant with respect to the DPDPA. So, with the roadmap in mind, let's start by understanding the DPDP Act of India's new data regime. Uh, First of all, to begin with, let's establish a clear baseline of what this landmark legislation represents. The DPDPA is India's first comprehensive law specifically designed to govern digital personal data. So far, we have had our IT acts, we have had our other laws and regulations, guidelines coming from various other entities, governing entities such as RBI, SEBI, and whatnot. But this is the first of its kind act in India specifically, wherein we emphasize at its core the act operates in a consent centric framework and not just talks about that you need to secure it. It's not just security that it has multiple scenarios embedded into it. So, this means that in most cases, we have clear permission to handle individuals' data, though the law defines a specific legitimate use. So far, the Indian entities and the businesses have been set in such a way that you can keep on collecting the data, but nobody really asks why you are collecting it. There was no particular law governing it, essentially. At a broader level, at an international level, we have had compliances and laws such as GDPR, CCPA, local PDPL laws from various other countries. But for India, we never had something like this. So the Act introduces two critical roles, that is your data principal and data fiduciaries. Just to give you an overview what these are the data principals are the individuals whose data we process. Now when I say we process, it's essentially the entities and the businesses that work in India. And these data principals now hold enforceable rights to access, correct, and even erase their information. Previously there had never been a scenario wherein a data principal or a normal user, for an example, let's say I am a normal user and I am giving my data to any entity. It would not have been so easy for me to go to them and ask that just erase my data, or I want to correct my data, I want to access, and I want to know what do you have actually on me. Those were the kind of roles which were not really they existed at a higher level, but they were never applicable on the entities by law. So that's where the data principal gets some rights, get more feasibility of using the data and enabling their own data. That's where the data principal has the upper hand with respect to this law. Whereas the data fiduciary is the role your organization takes. So for an example, as fiduciaries, we are legally responsible on how data is handled. Even if we use third party processors, the entity who is collecting the data becomes the responsible entity for everything that happens to it. Even if, let's say, I collect the data and I share it with someone, I collect all your data, let's say, and I share it with someone that's a third party. Still, it is my responsibility, not a third party's responsibility anymore. I have new laws and regulations that have come into effect that I have to fulfill as a data fiduciary. So all those particular parameters have come into effect. Finally, compliance of DPDP isn't just a suggestion. It's enforced by the governing law of India, and it's a digital first institution capable of conducting inquiries and imposing significant penalties for non-compliance. Uh, the Data Protection Board is not yet established. It's in the process of being established. We'll get more details as we move forward with time from the government, and it will come into the effect. But this particular data protection board that we have is actually an institution, you can say, which will govern every entity within India and will control all the flow whatsoever there is. So we'll deep dive into the details of each and everything and move along. So let's now focus upon the next segment that we have. Yeah. So this slide that you can see, it's the most critical part. So see, as an Indian mentality for businesses, I'll rather say people has been a bit laid back attitude with respect to compliances when it comes to security or privacy. The Indian entities have had that in the past, but they cannot do it anymore because the legal obligations that comes with this act also comes with penalties. Now, if you do not fulfill, you have to pay, and the amount is no small amount. These are huge penalties, as you can see on your screen, and these are very critical to the core of it because what used to happen earlier was that if you're not compliant, fine, you're not compliant. You get an auditor, you get everything done. It's okay. You get an audit report and that's it. It is no more like that. It's not just an audit anymore. It is very emphasized upon a number of factors that an entity itself have to maintain to make sure that they are compliant. Otherwise, the numbers that you see are huge numbers for any entity to pay as a penalty. So all these particular parameters, just to give you an overview. So for an example, the first one, the highest penalty that we have is up to 250 crore, where organizations fail to implement reasonable security safeguards, or where significant data fiduciaries fail to meet their enhanced obligations. Don't focus upon what is significant data fiduciary, what is data fiduciary. We'll get to that in just a while. But to give you an overview, what is at stake actually? It's not just the data loss. It's not just a reputation loss. It's a business loss. So this is where the government has come hard upon the organizations and make sure that everybody does follow it. So moving on to the next particular parameter, as I said, there are multiple entities involved, types of names I took earlier, fiduciary, principal. Now let's try and understand. To understand the DPDP Act, how it operates, we first need to identify who is involved actually. It's not just one person or two-person. There are sets that has been defined within the law, and we'll focus upon that first. So data principles, the individuals that you have, as I said earlier, the individuals who actually have the data, who actually share the data and now have rights, that particular person is the data principal, is the individual who actually does this. So at the heart of the act is the data principle. It is made for the people of India. This is the individual to whom the personal data relates, the person whose data is actually being processed. It is not just anyone who is walking around within an entity and gathering our data. It doesn't work like that anymore. It gives us right. It gives the data principle, the individual as a human person. It gives us rights to have it and to access it, to erase it. There are multiple rights that we'll get onto the later on stages. So the data principle is the individual. Also, within the data principles, there are specific mentions, specific called out scenarios for some exceptions, wherein the expansion also includes the children under the age of 18. They need to have a specific set of lawful processing of the data. Also, the person with disabilities or different abilities also have different ways to get the to work as a data principal or to exercise the rights. So which has never been for us. For in India, it has never been the case. Guys, I'm sorry if I'm going too fast. Please let me know because you guys are the best judge if you are understanding everything, and if you have any questions, please feel free to pop in the chat. And if it is okay and we're good to go, let us know. I would appreciate if we can get some engagement from everyone within the chat. It will be a better session, honestly. I don't want it to be just from my end. Okay, I believe people are there. And we have. All right, we have a lot of thumbs up. Thank you. I believe we can go forward. So yeah, see, data principles. This is the individual. That's the person whose data we are actually talking about. The next is the data fiduciary, right? Yeah, data fiduciary. So data fiduciary is this is the entity, whether a person, a company, or the state, the government itself, which determines the why and how of data processing. So far, it has always been in such a way that who's whosoever is processing, they never shared a lot of details around it. It was always a very minimalistic detail coming into the data principle, the individual, that how actually the data is being processed. So now it is a better mechanism for the data fiduciaries to understand how they can perform certain tasks and to make sure they give details to the principals, the data principals, that's the individuals, in as detailed manner as possible. So the primary responsibility is, unlike many other laws, the DPDP Act places the primary burden of compliance squarely on the fiduciary. They are legally responsible for any processing carried out, even if they outsource it to a third party. As I said earlier as well, that a lot of data can be processed by a third party. Do you guys understand what a third party is? Anybody have any idea? Can give me an example possibly to showcase that, what a third party could be in such a scenario. Anyone? The answer is right on the screen, honestly. I hope everybody is aware and awake. I hope people are not falling asleep. Yeah. Data principal, Shabana. Okay. Data principal would be a third party, you are suggesting. Okay. Logistics firm acting on behalf of a bank to deliver documents. Yes, it can be a third party. Correct. Any person or organization other than data principal, fiduciary, or data processor to whom personal data is shared. Okay. Vendors. Okay. What else? Travel companies for corporate travelers. Okay. Makes sense. Okay. So fine. I think we have an idea, right? I can see a lot of people answering with respect to it. Data of students in a university. Okay. So let me make my point clear. So a third party would be anyone who's providing services to the data fiduciary in this particular case that we are discussing. So, for an example, travel companies for corporate travels, that's written there. Uh, Logistics firm acting on behalf of a bank to deliver documents. Okay, vendors. These are the kind of entities. So, the data processors, the service provider, that are the service provider. And these service providers is the entity that provides services to the data fiduciary, not directly to the principal. So, for an example, I'll take a very simple example. Let's say as an individual, I have a bank. Okay, there's another one, the one who creates most of the risk but signs the least. That's true, and then, that is the scenario. I'll get to that in just a bit. So, yeah, as I was saying, so I myself am a data principal. Now, as a data principal, I go to the bank. I'll take the example that is written there. I go to HDFC. This is a hypothetical example. I go to HDFC Bank and open my bank account. Now, I get a lot of details from the bank that are posted to me or shared with me. The physical copies of my debit card, my passbook, my checkbook, all these are delivered to me. Now, the bank themselves are not delivering. They have a third party which is delivering on behalf of the bank. So that third party is particularly the data processor, the service provider that we have. Is everybody with me there? You guys understand what exactly I'm trying to explain here? So the data processor is an entity that processes personal data strictly on behalf of a data fiduciary, not by themselves. They do not get my data directly. So, for an example, DTDC. DTDC does not get my data directly. DTDC gets the data from another entity who actually wants to send something to me. So they work on behalf of data fiduciary and processes my personal data. So that's the flow that I'm trying to explain here with respect to data processors. Think of them as service providers like a cloud storage company or payroll vendor or acting under the fiduciary's instruction, as I said, DTDC or anybody like that, or any travel company for that matter. If there are corporate travel companies that are, uh, you know, providing services to Cybercube for my travel, they become the third party in that case because they get my details as a data individual, as a data principal, and they processes the data. Right? Is this clear? Do you understand the difference between the data fiduciary, the decision maker, and the data processors? If yes, please give me a thumbs up. It will be easier for me to understand. Perfect. Now, the last point you see is significant data fiduciary. Now, what's the difference between a data fiduciary and a significant data fiduciary? This is a very concerning and you can say complex scenario where a lot of people get confused. So let me try and explain as easily as possible. See, the government can notify certain fiduciaries as significant data fiduciaries. Now, what's the criteria for it? The designation is based on factors like the volume and sensitivity of data processed, potential risks to the rights of individual, or impact on national security and electoral democracy. The criteria has been very specifically designed. Try and understand that the any entity who actually possesses my data, a sensitive data, potentially risking the rights of individuals that are defined or impact on national security and electoral democracy. All these entities will be termed as significant data fiduciaries and not just data fiduciary. Okay, something is going on in chat. Okay, yes, okay. I think this was to my last question. So, once classified as an SDF, an entity faces much stricter compliance requirements. It's not just whatever the other entities have, they have a much more deep dive scenario with them, such as appointing a dedicated data protection officer based in India and conducting mandatory data protection impact assessments. This becomes an add on that we particularly have to identify for SDF. The SDFs have new specific requirements apart from every other entity that what exactly needs to be done. Okay. Is this clear, everyone? Okay, there is a question. So, if we compare with GDPR, data subject, data principal, data controller, data fiduciary, data processor, data processor. Yes, Arshad, that's usually the correct kind of comparison that you can do. I have a comparison later on in this stage in the webinar itself. We'll go through that what GDPR says and what actually DPDP says, so it will give you a better clarity of it. Okay, I hope this answers your question. Perfect. So let's move on to the next point. Yeah, right. So the moving on to the core legal framework of the act. How are we actually allowed to process personal data? This is something that is very crucial and is very important. Just one second. Very important that we have in front of us. So the grounds of processing. Under the DPDP Act, processing is only lawful if it falls under one or two primary categories. That is, one is consent, as you can see, there is one is consent and the other is legitimate use. So these are the two broader categories that they have defined and given the the whole law revolves around. It is important to note that the act has moved for specific legitimate moved away from the legitimate interest terminology. Earlier, the IT Act used to say, that, if you have legitimate interest, you can process the data. That's the usual term that has been used previously. So they do not use the word legitimate interest anymore. They utilize specific wording such as legitimate uses itself, and to ensure greater clarity and protection for data principles. That has been very specifically called out. So let's try and understand these categories and what other parameters that there are on your screen. First is consent. The first and most common ground that the DPDP Act has come up with is consent. This must be free, specific, informed, unconditional, and unambiguous indication of the individual's intent. So, this individual's intent that we are talking about, this is more or less the entity's intent of what they are going to do with a particular person's data. Essentially, the user must opt in very specifically, have an opt in with a clear affirmative action after being given a plain language notice. So, a plain language notice is very important in this particular segment, that whenever you want to collect my data, you have to give me a particular detailed consent, that why do you need it, what's the use case, for how long are you going to keep it, how you will process it, and whatnot. All those particular specific segments have to be covered. Whereas the second category that we have in front of us is legitimate users. However, these are scenarios, where obtaining explicit consent is either impractical or secondary to a greater legal or public necessity. These are categorized into legitimate users. So there are scenarios wherein you might not be able to have a consent, so it will be difficult, and that particular point comes under the section of legitimate use. Now, voluntarily provision is one thing that is there at the beginning of legitimate uses. If you can see, if an individual voluntarily provides their data for a specific purpose, like hand holding over a business card or entering details for a specific service, it is considered a legitimate use for that purpose. That's the voluntarily personal data provided for a specified purpose. That's the explanation for this particular segment. I think I'm missing something. Just let me quickly check if everything is okay. Yeah, I think we're good. Perfect. So, legitimate use, the voluntarily personal data provided for a specified person. That's one segment. The second is state government functions. So we usually call them state functions. Sorry. This covers the processing of data for government subsidies, benefits, services, or certificates issued by the state. So, for an example, let's say I have a driving license. So that driving license is a state function that is being provided by the government to me. And of course, they have data. They collect data. They collect biometrics. They collect my name, my email ID, number, phone number, address, and whatnot. So all those are the state functions. In that particular case, they can be collected without an explicit opt-out consent option. Just give me a second, guys. Okay. State functions. Okay. The next we have is legal functions of the state. Guys, feel free to drop a questions as we go forward. I'll come to your questions in just a while, but whatever questions and queries you have, you just drop it on the chat, and I will get back to you once I move on it and get a free specific segment. Uh, right. So the next is legal functions of the state. This includes fulfilling legal obligations, complying with court, uh, and or performing judicial functions. So all the court related activity or judicial related activities, the legal activities that the courts do on a day-to-day basis, all those are also legitimate uses where the data can be collected for any of the reasons. Next is safety and health. In critical situations, the law prioritizes life and safety. This includes medical emergencies where where the individual cannot give consent. So, for an example, I have been in an accident, right? Now, I hope I never am in such an accident that I'm going to say, but let's say I happen to be in an accident and I am not awake. Then what? Are you not going to collect my data? How are you going to contact my known people or my emergency SOS contact people if you do not have my consent? That is not a possibility. So, in case of medical emergencies, it can be bypassed. There has to be a legitimate use, of course, that an individual cannot give the consent by themselves. And medical treatment, in any which case, in any health crisis, these can be bypassed, and these are legitimate uses that you have. Then, disaster and public order. Processing is permitted to ensure safety during disasters or to maintain public order as well. Now, let's say we have seen in the recent past, the neighboring countries have had tremendously huge failures with respect to governments, wherein there were public order was not maintained. There were riots all around the countries, such as Nepal, Bangladesh, even if you go back in any country that you can see. So in that particular case, it is a legitimate use by the government that they can collect your data and they can take action against it. They can process your data. So by categorizing processing into these specific buckets, the DPDP Act creates a balance between protecting individual privacy and allowing the necessary flow of data by governments. As data fiduciaries, our first step in any project should be identifying exactly which of these grounds we are relying on. Why do we need the data? What is the use case? For how long will we keep it? All these particular parameters do come into the effect into this. We'll move on to the consent and notice under the DPDP Act. So earlier, if you note, if you made a note, I said that for consent, you need to have a notice. You need to showcase why do you need your why do you need the consent, or why do you need the data that you are collecting. So this is how you actually do. How valid consent works is consent must be free, informed, specific, unconditional, and unambiguous. When I use these terms, these are very broader terms. So let me make it a bit more clear for you. It must be given through a affirmative action. There has to be a specific something should be happening to make sure that the user actually understands it and opt in by themselves. By reading it, what exactly do you need my data for? It has to be very clear because it's a law. So, of course, laws are made in such a way that you can have a broader understanding of these things. But as a use case to use case matter, it differs. So, for an NBFC, that is non banking financial corporations, it can be different. For insurance companies, it can be different. Everybody have their own set of things. But for everybody, it is very important that they follow these particular segments. First of all, it has to be free. You cannot have paid consents. Nobody should be paying to give the consent. Secondly, it has to be informed. It has to be very specific. Why do you need it? And it has to be unconditional. There should not be any conditions called out. You have to do this to give us consent or to give us the data. There should not be. And fourthly, it should be unambiguous. It should be clear as it can be. There should not be any ambiguity in the written formats of how the consent notices are created. I hope it is clear so far. Okay. Now, what our notices must include? The notices must include the purpose of processing the types of data. Now, we collect a lot of types of data. And what exactly is the use case for each type of data? That has to be specifically called out in your notices. A clear outline for the rights of data principle. The user actually, what are their rights? What can they actually do with their data? And what is the procedure to follow through with that rights? So for an example, the exact process to withdraw consent has to be called out in your privacy notices. There has to be a grievance redressal mechanism that should be included in your notices before you collect the data and take a consent from any particular individual. Okay, so I have a couple of questions before we move into this slide and understand further. Let me answer these particular questions. Okay, so the first question is what is the threshold for volumes? See, Under the DPDP Act 2023, there is no minimum volume threshold for basic compliance. For basic, the data fiduciary ones, there is no minimum volume threshold. It is not defined as such. Even processing the data for one person requires a notice and consent. That is the how the law is made. There is no specifically. Whereas for significant data fiduciaries with enhanced obligations are typically, designated if they cross, I think, the threshold of around 20 million and or this 20 million is for a specific industry. I believe it is for e-commerce or social media or something like that, and 5 million users for online gaming. That's the major difference that we have. Okay, I hope, Ravi, that answers your question. Next, is will you be sharing this presentation? Uh, I think we are not going to share it. Maybe we can, maybe we cannot. I'm not so sure. But in case, if you want to have access to this presentation, you can probably drop down an email to us and we can get in touch and discuss how we can work around it or what kind of services we can offer to you. That ways we can do it. But as of now, by default, we are not sharing this presentation. I hope these answer the set of two questions that we have. Got it. Now, let's move on to the next segment that we have. Just give me a second. Let me set my screen. It just got. Yeah. Okay. So, practical steps to achieve compliance. These are basically 6 practical steps to serve as a roadmap for building a robust compliance. So we have segregated in such a way that you can understand each one easily. It is not a defined methodology that you have by the law. It is something that we have understood and came up with our understanding and experience that what you should do. So the first is data discovery and mapping. The identification of all the data that you have already had. So that's where we actually begins. We cannot protect what we don't know we have. I mean, it's impossible for anybody to do that. We need to perform a comprehensive data mapping exercise. This means documenting the entire life cycle of personal data, where we are collecting it, why we are holding it, who are we transferring it to, and most importantly, when are we deleting it. Under this act, storage of sake of storage is no longer an option. There has to be a defined storage period that you need to inform in advance and understand by yourself as well that for this long we are going to keep the data. So all these particular questions are very important to understand. That why we are collecting it, where we are collecting it, who we are transferring it to, and when are we deleting it. Make sure that you understand this particular segment very importantly because it's where you actually begin to understand where the data privacy laws actually come into effect for. This is the type and this is the baseline where you begin your privacy journey overall as well. So the next segment that we have is the review consent and privacy notices. You need to have consent and transparency. You need to, we, you must review your consent forms and privacy notices. The act is very clear. Consent must be free, specific, informed, and unconditional, and given through an affirmative action. The consent cannot be by default. It has to come through an affirmative action by the data principal. I hope this is clear. I am repeating it because it is very necessary for all of us to understand. So we need to ensure notices are written in plain language and eventually in multiple regional languages as well, so that users truly understand what they are signing up for. It should not be just, we need your data to process and give you services. No. Why do you need this particular detail? For what reason do you need it? How does it actually relate to your service? That has to be explained in your notices. That is one of the main core point of it. The next segment that we have is technical safeguards should be in place. So on the technical side, we are mandated to implement reasonable security safeguards. Now, reasonable security safeguards, this is the term that can be understood in any which way that you want. It is up to interpretation. And it's not just about firewalls. It's about encryption. It's about controls, access controls, and de-identification, such as tokenization and whatnot. The goal here is to prevent any unauthorized processing or accidental loss of data, shifting our posture from reactive to secure by design. Secure by design is a concept that is much more important and relevant when it comes to DPDP. Sorry, give me a second, guys. Okay. Now, the next is incident management. This is one of the major topics as well, wherein one of the most critical operational changes is our breach response processes. The rules are stringent. We have a 72-hour window from the moment we become aware of a breach to provide a full report, the total timeline from the moment the breach happened and to the final report is a 72-hour window. This requires a hot, swappable response team and a clear internal escalation matrix to ensure we don't miss this window. A lot of time it has happened in the past with other compliances that I've seen in the industry that a breach has happened and it was never notified on time, and people just took it for granted. If you do it now, there is a penalty that you have to pay. It's not just about informing your customers anymore. You have to inform the government as well. The data protection board that is going to be established, those have to be informed for these particular breaches. So implementing a good incident and breach management program within an entity is at most important stage. Next is the train the teams and document compliance. Now, this is something that is as important as the incident management part. That let's say you have a team for incident management, but they don't know what to do for it. Then in that particular case, it's of no use to have that particular team. So you need to make sure that everybody is aware of each and every step that they are going to take. There has to be detailed trainings for the teams to go through and understand what needs to be done when. That is where essentially the work actually happens, and not just creating the policies and procedures. The people has to be aware about, the people has to follow it, and that's where the real security is. Finally, for any high risk processing or new product launches, we will perform a DPIA, that is your data protection impact assessment. Think of this as a risk assessment for privacy, and under this segment, we analyze potential pitfalls before they even happen, ensuring that privacy is baked into the products and services from the very first line of code or any kind of service that you provide. This is very essential that every entity understands in such a way. DPIA is a very important aspect of it, specifically for significant data fiduciaries. I hope everybody's on board so far. Great. So moving on to the next is the DPIA. I've gone through this, so I'm not going to get into a lot of details here with respect to this. Yeah, let's talk about cybersecurity roles, specifically in privacy protection. Now, we need to understand that DPDP is often called a privacy law, but in practice, it deeply depends upon cybersecurity and not just privacy. You cannot claim privacy compliance if your systems are insecure. I mean, you don't have a password policy, you don't have any kind of access control, but you have privacy by design. You identify where the data is flowing. It is of no use. So, DPDP does not prescribe a checklist of controls. Instead, it expects organizations to implement reasonable safeguards based on nature of data, volume of data, risk of harm, scale of processing. That is where frameworks like ISO 27001, SOC 2, and security best practices become extremely relevant to have these kind of things in place. The second part is privacy by design. Now, privacy by design means thinking about privacy before feature is built, not after a breach occurs. An example of it would be asked during the product design stage. Do we need this data? How long should we keep it? And who should access it? These are the kind of questions that you ask before anything happens, before the coding starts, before the product is created. That is where the privacy by design come into effect. So all these would help you in the overall implementation of DPDP. The next is the readiness of future privacy and regulations. See, DPDP Act is just viewed as a starting point. In future, we can expect specific sector-wise rules, strong enforcement practices, and increased focus on emerging areas like AI-driven processing, children's data processing, and cross-border data flows. There are already regulations coming in from RBI, SEBI, and other entities, NPCI, and all, wherein they have their own guidelines that the entities have to follow. In future, other specific sectors would also start to have this, and we need to be prepared for it. Right? So privacy by design again is at the core of it. It has to be enabled as soon as possible. Okay. Now, additional obligations for SDF. Not all organizations are actually treated equally under the DPDP Act. If you have seen so far, I have been mentioning significant data fiduciary differently, data processor differently, and data fiduciary differently. These are three separate types. So not all the organizations are treated equally under DPDP Act. Certain entities may be notified as significant data fiduciaries based on scale, sensitivity, and the risk of their data processing. Appointment of DPO becomes the responsibility for any SDF that has been notified that they must appoint a data protection officer based in India. The DPO reports directly to any senior leadership and acts as the primary point of contact for grievance redressals and regulatory communications. The DPDP board should have someone who they can reach out to, who they can discuss things with for every SDF, and they need to have a data protection officer with it. Then there is independent data auditor. Sorry, independent data auditor. So SDFs are also subject to periodic independent data audits. These audits provide an objective assessment of compliance and data protection practices. In addition, SDF should also required to provide a DPIA assessment alongside these audits. It's not just that you call in an auditor like us and we perform the audit. Let's say everything seems to be in place. Fine, we give you the report. You submit it to the data protection board. That is not it. You have to perform periodic DPIAs as well internally to make sure that these are also submitted to data protection board alongside your audit reports. That is also one of the additional measures for STS. Right. So, yeah, appointment of DPO, additional measures of DPIA, independent audits. These are the major factors that you have to keep in mind if you are a significant data fiduciary. Right. This is an important section for any entity who is actually processing the data for special category of persons. This has been specifically called out and recognized that the act has recognized it, that certain individuals requires heightened protection due to vulnerability. For an example, first of all is children, of course, defined as individuals below the age of 18 receive specific safeguards. Organization must obtain verifiable, again, very emphasizing upon verifiable parental consent before processing a child's personal data. Verifiable parental consent, not their own consent, not just they had check marked it. No, you should have a verifiable method that a parental consent is provided to you before you process the personal data of a child. Additionally, the second point that we have is persons with disabilities or different abilities. by allowing a lawful guardian to act on their behalf as the data principal. This ensures that consent and rights are exercised in the best interest of the individual, and not just, people are not misusing or misbehaving with certain people and collect the consent unlawfully. There has to be a separate guardian, lawful guardian, who actually provides a consent for these. Okay. So we quickly give you an overview of what you can actually see on the screen. So there are three particular designations that we have made a comparison of. Now, the first is consent manager, the second is data protection officer, and the third is CISO. So this slide basically clarifies what's the difference between all these three roles and how they are conflated in practice, but which serves fundamentally different governance functions under a DPDP compliant framework. Now, it is usually, a very common question in the industry, that can a CISO be a DPO? Can a DPO be consent manager? Can a consent manager, DPO, and CISO all be the same person? So there are different use cases for each and every one of them. If you can see on your screen as well, you can easily identify what exactly a person's responsibility is with respect to various aspects, such as who they are, role of nature, primary focus, whom they serve, legal basis, key responsibilities, decision lens, and regulatory independence. The consent manager is not an internal compliance role. Let me be very clear on this. There has been a lot of questions around, and people do not really understand what a consent manager is actually. So, the consent manager is not an internal compliance role. It is an independent board registered entity. The board that I'm talking about here is Data Protection Board, that operates on behalf of data principal and not data fiduciaries or significant data fiduciaries. Its mandate is narrow and deliberate to enable individuals to grant, manage, review, and withdraw consent in a transparent and interoperable manner. It does not manage organizations' compliances. It does not represent the business that they are working for. It works for the data principal, the individual who actually is giving the consent. Then we have data protection officers. Sorry. The data protection officer sits at the center of organizational accountability. For significant data fiduciaries, this role is mandatory and is expected to function with institutional independence. Now, when I say institutional independence, it might be not clear. So the person should not be situated in such a position that it is their own personal gain if they bypass anything as a DPO. There should not be a personal goal aligned with respect to non-compliance. You may take it however you want. That's the easiest way to put it in words. There are a number of other scenarios within it. Then we have CISOs. The CISOs has a different mandate altogether. The CISO is responsible to protect systems, merging and managing cybersecurity requirements, the risks that there are, and responding to incidents. That's the CISO's role. That's where they operate. It's information security. When CISO is information security, then we have DPO, that is data protection, and then we have consent manager, which is altogether an individual, different individual, apart from these two. The CISO and DPO has to be separate for significant data fiduciaries. That is the requirement. Now, this is a brief, specific brief segment for DPDPA and GDPR comparison, just to give you an overview that where exactly it may differ. See, from an holistic view, when we look at the GDPR and DPDPA side by side, we see a sum of that Indian legislation has been influenced by EU1. However, there are also many changes. Initially, it came in as that, GDPR and DPDP. DPDP is just derived from GDPR. But of course, we are not European Union. We have different way that we work. Our legislations are defined in a different way. Somewhat similarities you can see, but there are major differences that are with respect to DPDP and much more effective in an environment that we live in India. GDPR applies to the personal data of individuals located in the EU, regardless of citizenship, and covers digital data as well as non-digital data that forms part of a structured filing system. Whereas DPDP applies to digital personal data processed in India or processed outside India in connection with offering goods or services to individuals in India, regardless of nationality. It applies to non-digital data once such as once such data is digitized. So it is applicable, but there is a very minor change of how it actually works. The GDPR is fundamentally a rights based framework. Its starting point is the individual giving people strong enforceable rights over how their data is used. DPDP, on the other hand, is more consent centric. It focuses to ensure that organizations collect and process data only with valid consent or narrowly defined legitimate use. You try and understand the difference. One is rights based, that is GDPR. It is not like that DPDP is not rights based. It have its own rights. It gives the data principles its own rights, but it emphasizing much more on the consent at the initial level that you give to the entity. Okay, so from an overall perspective, that's the major differences that you can have between the GDPR and DPDPA. Okay, let's move on to the next slide. I think we are almost running out of time, so I'll quickly get on to the points that the major different aspects are individual rights, compliance responsibilities, breach notifications, and international data transfer. These are the major areas, as you can see on your screen, with major differences. I'll give you a second to go through these. Okay. Uh, Nit, I see your questions. I will get back to your questions in just a while. First, I'll go ahead and finish off the webinar first. Okay, so the next set that we have. Uh, uh, right. So important timelines. Now, there are specific timelines that has been provided by the law, and these are very important for any entity to abide by for making sure that they are compliant with DPDP. The first is personal data breaches. Uh, Under Rule 7, any breach triggers immediate escalation. Affected data principals must be notified without delay, with the Data Protection Board must receive an initial intimation immediately, followed by a detailed report within 72 hours. So, for an example, if something happens, a breach happens, you inform the Data Protection Board, you inform the data principals, and then within 72 hours, you give a detailed report to the Data Protection Board saying what happened and how it happened. Second is erasure of inactive user data. Under Rule 8, with the third schedule, specified classes of entities, including large e-commerce, social media, and online gaming platforms, are required to erase personal data over 3 years of inactivity. That is what is specifically is the timeline wise for Rule 8.2. Crucially, this must be proceeded with a 48-hour advance notice to the users. After that 3 years of user intimation, 48 hours prior to deletion, you have to inform them that this is going to happen in the next 48 hours. Then under Rule 13, once the entity is formally notified as an SDF, it must conduct annual DPIA and data audits calculated from the date of such notification. So yearly starting from 13 November 2025, notification date of DPDP rules, or the date a DF becomes a SDF. These are the two timelines. Within a year, you have to submit a DPIA as well as an audit report. For first schedule, part B4C, maintenance of consent records by consent manager. It has to be maintained for 7 years. Every consent manager has to maintain the records for 7 years. Response to grievances of data principals within 90 days. So within 90 days, a response have to be provided to data principals with respect to all the grievances that they have had by the data fiduciaries. Okay, so the next couple of slides, I'm going to just give you a walkthrough and not deep diving into the detail, just to make you understand that how actually it happens. So whenever an entity has to take on board that we need to be DPDP compliant, then in that particular case, the project technology overview that I'm going to go for is very important. That you understand these are the steps that has to be taken in the way it is written as of this moment. So the first thing is that we identify the scope and awareness, and then we perform a data discovery and flow mapping. Then the next part is gap assessment, and the fourth point is compliance framework development. So we draft all the DPDP related policies, procedures, and whatnot. Then we do the control implementation for privacy and security reviews, and then we perform a risk based assessment and conduct DPIAs as well in parallel to it. Once the gap closure is completed, we will perform a validation, and then there has to be an ongoing monitoring scenario that has to be taken care of. Okay, so yeah, I think you understand the flow of it, right? So as we wrap up today's discussion, the most important takeaway is that India's DPDPA Act represents a fundamental shift from data ownership to data stewardship. Compliance is no longer just a legal requirement, it is a vital component of building and maintaining trust with your customers and partners. The roadmap we have discussed today, for understanding lawful processing to establishing robust breach protocols, is a significant understanding. While the deadlines may seem daunting and you don't have to navigate this transition alone, at CyberCube, we do specialize and provide services with this particular parameter. Now I will leave the podium open for the people. If you have any questions, I believe there are some questions that I need to answer. You can drop down your further questions. Or if you have any specific queries, you can reach out to me on the email ID. I would request the host and co-host to put down the email IDs in the chat so that people can reach out to us with their specific queries. If you have something that you want me to answer right away, you can just probably drop it in the chat and I will try to answer those. I think there are a few questions. Give me a second. Yeah, Prathmesh, how will the consent manager and consent management systems deployed by an organization interact? Okay. How will the consent manager and consent management systems deployed by an organization? I'll leave it to till organizations. See, the consent manager is like a central remote control app that the user actually uses to say yes or no to different companies. The company's internal system is the engine that actually receives those signals and automatically starts or stop using the personal data based on the remote command that is being provided by the data principal. That is where you can easily reach out and you can easily implement for any of the entities. Okay.